biochemistry and biophysics at UPenn in the Medical Center, trying to do some clinical research and preclinical research, and I had no idea what patents were, and I had no idea when we should be talking to our tech transfer office to talk about inventions. Fast forward, I found my way into patent law from hard science and spent the last 20 years working in private practice, working for judges who dealt with patent and IP cases, one at the ITC, International Trade Commission, and one at the Court of Appeals for the Federal Circuit, which is the regional circuit court that deals with all patent appeals from across the country. In that private practice area, I also dealt with a wide variety of issues beyond patents. So while I'm a registered patent attorney, copyrights, trademarks, trade secrets, all of these different tools that is in the tool chest when we talk about IP protection. I've also run my own business, I've merged my business, and then I've sold my business. So I've been through the full life cycle with the business and have lots of fun war stories for anyone who wants to grab a drink when we can open shop and talk about them. Happy to share my pearls of wisdom for what it's worth. So with that background, I want to talk to this group about some of the interesting practical issues that we need to think about when we're looking at intellectual property protection for AI, including ML. So what we'll go through in this discussion is an overview of the basic protection options. And here I'm going to not only focus on those that are most important for AI, but also talk about the different protection regimes and what they're intended to do and how they protect you. Then we're going to get into R&D considerations. I think that's very important for this group to understand when you should start thinking about IP and how you should start thinking about IP. No discussion of AI is complete without at least mentioning the common licensing regimes we have to be aware of when we're on GitHub and we're looking at some tools, whether it's data sets to start training our tool or other open source technologies that may be useful to go ahead and build our AI technology. From there, I'll move into patent protection options and issues, some fun emerging tech issues that involve AI and other emerging technologies. Then I'm going to finish up with some business issues and collaboration things we need to think about as we start to move beyond that early bench research stage through the life cycle to potentially commercializing a technology. Those are the things we should be keeping in mind even at the early stage. So with that, let's talk at a high level about the protection options. Generally, they fall within these categories: copyright, utility and design patents, trade secret, trademarks, and contracts. That's a legal document-based set of protections we're going to cover. So starting first with copyright, because this is one of the most important IP protection options for software and AI technology in general. So copyright protects the fruit of an author's labor as they're developing software code, as they're writing a textbook, as they're creating a beautiful piece of art, right? There's a wide variety of items that can be subject to copyright protection. That includes technical drawings and architectural works. So if you've ever seen the very complex technical drawings for buildings that architects put out, those also can be protected by copyright. This is particularly important for AI when we talk about tools like Autodesk and generative design tools that will output three-dimensional or two-dimensional drawings that result from their particular evaluation of the underlying data inputs. So copyright protection, it's important to understand that it protects against copying. That means if somebody else takes a portion of your code without authorization and then imports that into their own product, that can violate copyright protection. It does not, however, protect against somebody else developing their own software code that's designed to provide the same functional output. So it's important that you understand that distinction because that's very different than what we protect with patent law. Finally, there's a long period of protection for copyrights, decades and decades and decades. You can thank Walt Disney for that long term of protection. Moving now to patents, there's two basic types of patents that I'm going to discuss today, but there are also plant-based patent protections that I think is a little outside of what we want to cover. The two basic types are design patents, which protect the ornamental features. So here you see a pretty famous shoe design that has some of the designs that are protected by patent. This one has actually gone through a couple of litigations. The bottom picture is actually the design from a generative design tool. I mentioned AutoCAD before. Philippe Starck used AutoCAD and its generative design features to develop a new chair design. And this particular chair launched in 2019. It's been well received. I will get to why the resulting design from the AI tool is not protected by patent law later in this presentation. With respect to the utility patent protection, utility patents protect the useful aspects of an invention. So whereas design patents might protect the shape of an iPhone or some interesting ornamental design features on the front of grills, like the egg grill, if you've ever seen that. It's a very distinctive design. Utility patents protect the useful parts of innovation. So if we think of things like medical diagnostic tools, the usefulness comes from their ability to test for particular disease states, particular excipients in a particular chemical compound. The list goes on, right? That's the useful feature of it, and it's protected by the patent claims. Then we move to trademarks. Not so much of interest when you talk about the underlying AI technology, but I have up here Amy and Andrew Ingram's XAI. So this is an AI smart assistant whose sole purpose in life is to help you schedule your life. I have to say I started using this tool during beta testing, found it incredibly useful. So if you go to XAI, you will learn more about the tool. They're not a client, I'm not plugging them, but all of that is to say even AI tools need some trademark protection around their brand. You also see two other examples here of very important and valuable trademarks, and one of the most famous trademarks that has the highest valuation, some say over 1.5 billion in terms of its valuation, is the Apple logo. Then we move to trade secrets. So trade secrets, this concept is designed to protect the things that companies or individuals keep secret, so they don't share it with the general public, and they gain the value in terms of their competitive edge, economic edge, by the fact of that secrecy. So you already saw a Coke logo. The Coke formula is one famous example of a trade secret. There are other commercial product compounds and recipes that are also protected by trade secret. And we're going to talk a little more as we go through this presentation about opportunities to protect AI and importantly, your algorithms or some of your other underlying processes relating to AI via trade secret protection. Then we move to contracts. So contracts are not normally thought of as a form of IP protection, but they're becoming increasingly important as businesses are doing business across geographic bounds where different IP protection strategies apply. So most IP protection, just for your information, is geographically limited. We have certain laws and certain protections in the United States for trademarks, patents, copyright are all geographically limited. We do have treaties with other countries that allow some of those protections to go across borders, particularly with copyright protection, but generally the protection is limited and you have to pursue patents, for instance, in each geographic market where you might want to protect your technology. that becomes very expensive. So another way to think about layering on your protection and keeping your competitive edge for your technology is to use contract provisions and terms. Some of those contracts, for instance, if you read a EULA for very popular technologies, they probably don't give you any license to any of the underlying IP that was used to develop that technology. So when you use Amazon site to purchase products through their e-commerce platform, for instance, there are very significant AI algorithms in the background and understanding your behavior, serving up content that might be interesting to you, and really analyzing your behavior to improve your experience on those sites. You do not have a license to that IP, you have a license to use their e-commerce platform. So now we move to R&D considerations. You're thinking about developing an AI tool. Where do you go? What do you start with? So I know from our own R&D department here that it's wonderful for all of our people to get onto GitHub and go out to other platforms to start to understand what modeling is available via open source tools on GitHub and other platforms, what kind of data sets are available to start training their AI and start developing their model. And then there are a host of other functions that can be accomplished through open source technology, whether it's a full-fledged program or a library or just a platform that's open and is a common language for people to use to develop particular technologies. It's really important to understand the licensing structure associated with those platforms before you start, particularly if you're thinking about launching a tool commercially or selling it commercially. Then, when you're looking at other commercial technology, some might be available through a website, through a software as a service offering. It's important to understand the terms of service, the end user license agreements, the privacy policy, and other licenses associated with that technology. It's also important to understand the privacy policies. If you're doing a project that can be considered sensitive, let's say you have a private industry partner that's paying for development of particular technology, if you're using that site in terms of searching or in terms of developing an understanding of a particular aspect of an algorithm, what is that site learning about who you are, where you are, and what you're developing? This is something we're significantly concerned about when our 30 people R&D department go out and start searching the internet. And then finally, you need to understand the restricted licenses associated with that technology and what licenses you need to think about if you're actually modifying that technology. So for instance, if you're taking commercial technology and you're loading AI on it, you have edge node AI that you're trying to implement within a particular grid system or within a network. What does that mean with respect to the licenses that you have and your obligations with respect to the underlying commercial technology and the license that go along with it? So here's just a listing of some common license programs. You're probably familiar with these if you've spent any time on GitHub or even some of the open source sites that have photos like Flickr. So now we get to the question about AI patents. Can we get patent protection for AI? I want to talk about this in two ways. First, let's separate the software code and the processes that the AI goes through in order to create the intended output. Looking at the underlying software code and how it works, you may be surprised to hear that a patent attorney is going to tell you that may be a bad option for you. The reason why is, as Chuck mentioned before, we've had a series of significant opinions coming out of the US Supreme Court since 2010. And the Federal Circuit, the court that I clerked on, that. Those opinions have generally been considered by the patent bar to be inconsistent with each other, create a lot of confusion and ambiguity around the legal requirements relating to getting patents on technology that might be considered abstract ideas. That's the magic word that they use. And the reason why that's important is because abstract ideas are exempt from patent protection. There's a particular provision of the patent statute that has been read quite broadly, particularly within the last 10 years, to get rid of patents that have already been granted by the US Patent Office when they are enforced in court, or for the USPTO to refuse to give a patent application approval to become a patent. So one of my good friends, Dr. Mossinghoff, has called this the 4 horsemen of the apocalypse, and I've listed the major Supreme Court cases up here. So Bilski is a case that involves a business method, and this particular case came up in 2010, so it was 10 years ago. Many people at first thought, you know, this is a blip on the screen. This is not something that's going to apply to all software patents. Then came the Alice case. This was a software case. And in the Alice case, the Supreme Court developed a very broad and general opinion or framework whether patent applications determined to be patentable or abstract ideas. We have the Association for Molecular Pathology the year before and Mayo Collaborative, both biotech cases involving diagnostics. Both of these cases, the Supreme pushed further in terms of this particular framework and killing patents associated with diagnostic testing. So then we come to, okay, and since then, why think about patent protection for their tech? The good news is of the USPTO focused on this issue and that over 500 patents have been killed because of this particular more expansive reading of the statute. So they have attempted to provide more clarity through a series of guidance documents to the industry. The problem is the Federal Circuit, the appellate court that deals with all patent appeals across the nation, has said, and this is not surprising, you know what, the USPTO guidelines don't apply to us. We can do whatever we want to do, and we follow the Supreme Court law. And the Supreme Court has received numerous requests to clarify its law, get rid of ambiguity and perceived conflict between the decisions. And so as of January 2020,
Darn, I think we lost you, Antigone. Oh, you're back. Yeah, so there's your audio's cutting out every now and then, and it cut out for about 5 seconds there. Please continue.
Sure. So probably where it cut out is I was mentioning the fact that there have been many petitions to the Supreme Court over the last few years, but none of those have been taken up. So everybody's looking to Congress to provide more clarity and better and more reliable protection for patents. So this has had a real-world effect in terms of patent filings in the US versus patent filings abroad. So while it's gone down over the last few years at the USPTO, the total number of patent filings, and it's even more stark when we look at the software technology art areas within the office, there has been significant increase around the world, particularly China, Europe, Africa, and Middle East. So then we go to emerging AI and tech issues. One of my favorite topics when we talk about protection for AI, really a fairly famous case involving a European photographer who had a photo that a monkey took of himself. And this was the very famous monkey selfie. He then went after TechDirt and Wikipedia for putting the photo, the very famous photo, up, arguing that it was his IP, that he had the copyright on the photo. They responded and as well went to court and got confirmation from the court that when you have a non-human who takes a photograph or creates an image or create a piece of art or otherwise create some output, there's no copyright protection for it. So PETA has followed on this theme. It has filed lawsuits on behalf of bonobos, dolphins, and others. And in all of these cases so far, the courts have said, nope, these are not authors under the Constitution, so whatever they create has been dedicated to the public. So that means that nobody owns this photo. So why am I talking about this in an AI presentation? The reason why is the same thought process has been applied to the output of AI. So if you're using a generative design tool to develop a different way of thinking about a biomedical device and how it's structured, or a drone leg. There's been some really interesting applications of generative design to airplane parts, to input data about tensile strength, flow, all of the material implications that are needed for that particular part. And they've gotten some really interesting designs out. But the answer has been pretty consistent from our offices in the US as well as abroad. If it's simply output of the AI tool without any human intervention and interaction, it's not protectable by copyright. So what this means, and thinking about what you do, if you're interested in protecting it, there has to be some deliberative decision to modify that design on the human intervention in terms of the final design you intend to protect. So I'll give you an example of a commercial company that does this. There's a startup I'm aware of that uses all of the building codes to develop the first version of an architectural design for homeowners and buildings in particular regions. So they take in all the data about building codes, they create the initial design, and then they have a fleet of architects who are then hired homeowner or the builder to then modify that design for their particular project. So that's a way that they've effectively been able to layer what's unprotectable with additional efforts by human that makes the final output protectable. I'll also briefly talk about blockchain IP complications. So if you've had any interaction with blockchain technology, I'm going to put crypto aside for a second, but generally using blockchain technology and AI interaction with blockchain. Many blockchains, particularly the more useful or used ones, are a combination of open source or run by non-for-profit consortia. So if you're thinking about developing something that you want to protect through IP that's sitting on top of a set of tools and protocols on an open source blockchain, that's something you need to consider in terms of creating that follow-on proprietary technology. You also need to think about what, if anything, you're required by your agreement in order to use those tools or that underlying protocol with respect to what you have to give back to the consortium or the association. The final issue relates to proprietary versus standard technology, right? So sometimes we live in worlds where we're using standard technologies like TLS encryption, right? This is a standard for internet-based communications. That's a standards-based technology. So if you're trying to develop something that's really an add-on or part of that standards-based technology, you need to think about the patent pools and the other aspects of standards development. Again, it's coming in with an awareness as to what the existing IP rights are and how your plan for IP protection relates to those rights. There's a few other business IP issues I can raise, and this really gets to that second level of commercialization. So contractor and employee assignments. If you're interested in making sure that every contractor or employee who ever develops something for the company that may be protectable by through some IP license or IP protection regime, patent, copyright, or other, it's really important that you have the formal assignment of their rights within those contracts. The university collaboration or tech purchase, when people come to the university and they say, we want to work with you in developing a particular technology, both the university and the private company have to understand who owns what rights. Additionally, when you're in the university and you're looking at government contracts or grants to develop certain technology, you have to be aware of what IP rights the government has to that technology. For many programs, the government has a fully paid license and the right to create in the copyright world the derivative works. Chuck mentioned SBIR, STTR at the NSF. That's a program where the NSF doesn't get those rights. It's an expectation that you will keep all your IP rights, even though you're getting a significant grant for that early stage development. So it goes back to understand the rights. And then finally, business across borders. So this is very interesting when you're thinking about collaborating with another university that may be located abroad. We actually have export-related restrictions on certain types of software codes, certain technologies like VPNs. And so when you're thinking about those collaborations and actually moving software code across those borders, it's important to understand, even though you live in the university, some of these export rules still do apply to you. So another thing to think about when you're figuring out which of these protection options might apply for a particular AI technology that you're building, it's helpful to understand your deployment model or your intended deployment model. So for instance, if you have an AI tool that you're building that you want to protect, but you're offering people's opportunity to interact with it through a software as a service model, where they're interacting through a browser, they're not getting access to that underlying source code. You're not dropping it on their enterprise system and running that code on their system. So that might be a situation where trade secret protection is an appropriate method to protect it. And then it's really a focus on putting appropriate physical and electronic security measures around that trade secret and documenting it appropriately. If there's internal system only use, does it make sense to go after patent protection instead in case somebody else independently invents, right? So you're not putting it out in the world, but you don't want others to put it out in the world and then argue that you're infringing their patent. I already identified the enterprise model, and then user devices, right? If you're developing an app that uses AI that's living on a user device, there is some level of access to grab the code, even though it's compiled code, or to do other things to potentially. So again, that's part of the thought process around what sort of protection might make sense. Perhaps with user devices where they have direct access to the code, they could pull it via Celebrite, one of the e-discovery tools, for instance. Maybe copyright protection makes sense for you. Commercial versus government markets, right? So when you're looking at commercial opportunities for development and actually commercializing technology, you can use the commercial rules of the road. As I already alluded to, when you're looking at government markets, there are a whole set of different rules and IP rights that apply to those two worlds. I want to make sure I leave time for questions. I'm going to go on to collaboration issues. So hackathons, this is one of my favorite topics. I say hackathons are for IP hacks because while they're a lot of fun, it's really generally a group of people getting together at a developer conference or a company sponsoring a hackathon. And if they want to then develop the technology and take the code that's been created during the hackathon forward, they've got a big problem. So when's the last time you went to a hackathon where as you walked in the door, they said, hey, thanks for coming. Here's your IP assignment document. Please sign it and make sure that I get a copy before you leave, right? That doesn't happen. So I've seen several situations with commercial customers, including companies I've worked with in the past, where some portion of the technology was developed through a hackathon, and then when they go to file for copyright protection, for instance, and we go through the list of everyone who ever wrote a line of code there, because they're all authors, unless they were employees at the time, we decide that there are 2 or 3 people who they don't know where they are, they don't know how to get in touch with them, and they can't get the assignment of the rights. So they have to start from scratch with that code or find another way to deal with it. So that's why we need to just be clear that hackathons are great places to ideate and solve problems. It's not a great way to develop a technology that you intend to protect by copyright law or commercialize. Other collaboration issues that come up, and this is certainly true for the university sector, what happens with sharing improvements, right? So we're in the world of COVID. There are many collaborators around the world who are developing and publishing openly improvements or information or understanding of what the sharing rules of the road are is very important. Then there's these other concepts, I'm sure you understand them. Permissions, the scope of a license, what a company or an can or can't do with a particular technology. And then finally, security and accountability programs. So if you're developing a technology and you're offering it into the commercial world as a product that people buy, what are the security and accountability programs? This is less of an IP issue. It's more of an integrity of an AI tool issue as you move forward and you look at the life cycle of an AI. So whether it's an AI that's engaging in continuous active learning after it's publicly released, or whether it's released to a commercial customer, or it's something that has been fully trained before deployment, you just have to understand what that relationship looks like and how you're going to collaborate with the partner or customer to ensure that the tool continues to provide the results that are expected and intended as it matures and moves out into the world. So here's a few final thoughts. When we talk about IP generally, we need to make sure that no matter whether we're doing it within the university or at a private commercial company, we need to understand what physical and electronic security measures we're putting around our AI IP. So do you have a private GitHub instance that you're using for development of a particular technology that was paid for by a private commercial partner that's doing the direct payment for university development? Or rather, is it something that really does belong on GitHub, in the public GitHub, available for the world to see? As I already mentioned, the strategy should start before R&D. What's the intention with this technology? Is there a commercialization intention? Is it intended to be a basic bench research tool for internal uses only? Those kinds of thought processes should drive the deeper thought about IP protection and also the electronic and security protection measures. And then get creative with protection. So while I said that there's significant uncertainty about patent protection relating to software in general and business methods in general, there may be ways in which a particularly creative solution could be protected by utility patent, but the underlying code could also be protected by copyright. So that is to say, these are not mutually exclusive categories. There could be multiple ways you protect the ultimate commercial product just by looking at the different protection tools and seeing which apply and how they apply. And then finally, I want to make sure you have my information. If you have any follow-up questions that I can't answer during this presentation or we don't have time to answer. So this is my email address. I also want to make a plug for our R&D department here. So as I mentioned, we've got 30 individuals within our R&D department at Ridgeline whose sole purpose in life is to tear apart technology, develop signals, develop AI models, and they're a very rapid development shop. They go from ideation to fully deployable solution between 6 and 18 months. So it's a very fast turnaround. So if you're interested in an internship, please contact Matt Mead, our talent acquisition manager. We're always looking for smart people. And even if you're still in school and you just want to do an internship and externship, you know, we're very familiar with the issues that COVID has raised, but we have been able to make most of our R&D department virtual so that our current interns can also participate in their internships and R&D efforts. And then finally, if you're interested in collaboration and partnerships with our company, I should actually tell you what we do. So we develop all kinds of software and hardware related technologies for commercial and government customers, focused on secure communication technologies, special mobile devices, special signature and signal management. I mentioned AI on the edge. That's a major focus for us now. So we have a wide variety of communication and technology solutions we've developed, and we continue to develop. So we're looking for smart people to join us. So with that, thank you, Jeff and Chuck, for your indulgence on that plug. I'll now turn it over for questions or comments, and thanks everybody for attending.
Well, great. Well, thank you, Antigone. That was great. It was a great survey of all the aspects of a business, and translation is important. I want to start it off with one question. Well, people can put questions in the chat or raise your hand, and we'll figure out how to do that. After Alice, there was a two-part test to see if a software patent and claims are patentable. And many of our researchers here have run across that with tech ventures. It comes in that I know the first is it an abstract idea? And if you could give some examples of that, maybe in a technical field, technically related to give a context here, but describe what the second aspect is that will make it, and what the two-step process is that's now being used by the Patent Office.
Sure. So this is called the Alice Mayo framework, and this was, it started to be developed in the Alice case from 2014, but as other decisions have come along, the framework has been described in a little more detail. The underlying question or concept is that abstract ideas are not patentable. But if there's something more than that underlying abstract idea, then it's patentable, right? So when we talk about the question or the concept of abstract ideas in the area of AI, it's generally understood among the courts and among patent attorneys that just the algorithms or mathematical models, if you were to try to put in patent claims mathematical models or algorithms just by themselves, that would be an abstract idea and not worthy of patent protection. The something more is an area where lots of people and lots of courts disagree on what that something more is. But let me give you an example of what something more may be. If the mathematical model or algorithm that is described in a claim then produces a particular physical tangible result. So let me use the 3D printing for a second. If you use a generative design model, and in your patent claims, you also describe the output of that, which is a particular, I'm going to use a drone for a second, with various configurations and certain apertures of a certain size in the legs and certain aspects of the platform that are new and different than others. You have in effect put in the output of that AI into the text of the claims. So that is generally a way that patent attorneys think about, well, you know, as long as I get this physical, tangible result in there and I describe it with some level of particularity, I stand a better chance of actually getting a patent. The problem with that is then the patent scope is greatly reduced. So you are then living and dying by those parameters of the physical, tangible result of that design that you've described in detail within the patent claims. So variations on the platform of the drone or variations on the description of the legs of the drone, somebody can do what's called design around, right? They can look at the patent claims and say, okay, these are the parameters that are designed as described as the output. I'm going to make some modifications that go outside of those parameters, and I'm going to design around, and therefore I do not infringe this patent. But that's one example of a successful set of claims that have been described in some of the examples that the USPTO have given out. But I've inserted drones in there for some other technologies.
Great. Okay, thanks. We have a question. We have a couple of questions here. Kirby Gong, if you want to unmute and ask your question.
Yeah, hi. Appreciate you taking the time. My question is that in general, it's an important part of developing an AI is your data set, right? So I was wondering, are there any, I guess, legal protections for protecting a data set? I don't really know if it's a thing, but yeah.
Yeah, great question. So there's a wide variety of open source data sets that are out there, but particularly with image data sets, one of the things that I've seen companies start to do is file for what's called a collection copyright. This is what photographers have been doing for many years. They have a whole slew of photos from a particular trip, or they have a set of photos that they're putting in a coffee table book, and they file for copyright protection on all of those images as part of that collection. So I know that companies that, particularly when we're talking about ML, and they've created a really nice data set that they're offering for license on GitHub or another open source for a fee, they're then filing for that copyright protection for that entire collection for that underlying data set.
Okay, Kirby, is that any?
Yep, that was great. Thank you.
Okay, good. Hamed H, you want to unmute?
Sure. Yeah, thank you for the presentation. So, so one of the things that we do is just using the patient's images, and we do like modification on them. So, and if I understood you correctly, you mentioned that the output of generative models won't belong to anyone or belong to public. So in case of patient's data, after we use it in an AI model and generate it, for example, a modified image, does it still belong to the patient, or is it, I mean, what is the, regulation for that?
That is a great question with a number of things I want to cover in the answer. So let's start first with there's a wide variety of privacy and Hipaa compliance issues that you need to consider when you're dealing with patient data sets, including those data sets that are being used to train a model, right? So before you might provide even a subset of those for others to validate the data set, you would need to make sure that you're complying with the Hipaa requirements, including the business association requirements for university partners that are participating with the company that gave you the data set. In terms of the protection for the underlying data set, it sounds to me like you're suggesting an augmentation on, let's say, a radiology image to help identify for the AI tool the most interesting aspect of the data. And in that case, I'm going to go back to a standard copyright concept called transformation. So if there's something that, let's say, a photographer did not develop, but they're using Photoshop to change colors, blur the edges, they're doing a lot of things to alter a image. At some point they get to the point where they've made so many modifications that they've transformed it from the underlying photo that's protectable only to the photographer, and they've created a piece of artwork, if you will, that they may have their own protections in. So this concept is common in the world of music mashups or image mashups, right? Where you have this whole culture of people that are taking openly available images or music and mashing it together. So there could be that sort of protection if there's such a level of significant changes to the image and this underlying data set that, putting the privacy or consent issues aside, you have transformed it to a point where it is a creative endeavor that can be protected by copyright. So hopefully I answered your question. Let me know if you have any follow-up questions.
Thanks.
Thanks. We have a course here where the students are working on clinical problems that are presented by the clinicians at the hospital, and they develop algorithms or software packages which will use patient data, real-time patient data and time series patient data to determine if a patient will transition into a worse state, it can be discharged from the ICU, is going to develop sepsis or heart conditions as they leave. And the students are wondering if this can be protected for commercialization. What would you say to them?
You're talking about the patient data directly?
No, not the patient data, the algorithms that the students develop, that a team develops, or there's another team who's developing a user package where it analyzes the chances of patients returning to the hospital after CHF.
Yes, very important set of research. We don't want them coming back. Hospitals get penalized if they come back within a particular period of time. Yeah, so this gets back to whether the mathematical compilation or mathematical concepts or the algorithms themselves are protectable by patent. So if we're just talking about those algorithms by themselves, that's not a good candidate for patent protection, particularly in the United States, but it's also true in the EU and many other jurisdictions. However, it can be protectable if, let's say, it's only being used internally. It can be protectable, believe it or not, by trade secret. And it can also be protectable via copyright, right? Because those algorithms are reflected in source and object code in terms of the compiled code that's running those algorithms on the data. So I think in that sort of situation, that would be the natural place where you're looking at copyright protection. Copyright protection, there's common law protection. So once the algorithm's already written, there's common law protection there. But if the university, depending upon the grant situation and right situation, chose to actually file for copyright on it, all that really involves is filing with the Copyright Office, filling in the information in terms of authorship and ownership, and providing a what's called a deposit against that code, which interestingly the office calls the first 25 pages and last 25 pages of a text work. And you got to laugh when you hear that. This is the old copyright code being applied to software, right? So there's no such thing as the first 25 and last 25 pages in a copyright code versioning system or platform. So that's where some interesting discussions happen around what code should go in and the fact that the most sensitive code should not be part of that deposit.
Yeah, okay. If one of the things I might mention about that is if they think they've got a protection on that, can you talk about a workaround for somebody who uses, I mean, if they protect that and somebody comes up with another algorithm that they've developed on their own, how much value does it have from a commercial aspect? Oops, did you hear me?
I lost you, Chuck.
Oh, okay. Okay, well, with only a little bit of time, Fred, if you want to unmute, you can ask your question.
Yeah, thanks for the presentation. I was wondering, in the beginning, you pointed out that copyrights protect the software's printed code, whereas the patents protect the function. And the function patent will expire. I assume the copyright lives on. And I know in music, just a few lines or even notes of a tune can lead to copyright infringement. What about fragments of a software code?
Great question. So you may have heard of the Google v. Oracle case involving the Sun Java code base, and what happened is Google, without authorization, used just, I think it was 0.1% of the code for the entire code base that involved the APIs that talk to mobile device software tools. So that was a very small percentage of the code, but that went all the way up through the court system, and the courts decided that that little tiny bit of code is protectable under copyright law, and the use of that code constituted infringement and was not fair use. So that's one example of a little bit of code that's highly valuable can go a long way in terms of protection. On that same note, Oracle has been quite successful in going after companies who are simply downloading patches, bug fixes, and small software updates, and accusing them of infringing the underlying code because they don't have an ongoing license, an active license to that software. So there's been some pretty significant decisions in the last 5 years around a small bit of code that's important can go a long way in terms of showing infringement.
Thank you.
Great. Okay, well, we have time for one more question, and Jeff, as the organizer of this, gets to ask that.
Oh, I don't know if it's a climactic question.
Well, sorry, Jeff, you're on the spot. We're out of time, so
You know,
make it climactic.
An interesting new challenge that we faced recently was the idea that software that appeared patentable in its relation to a hardware system, and things seemed pretty good there. But the challenge to us was the ability to prove infringement on the method, so that if someone had reproduced the method and was therefore infringing on our patented system of software, how we could prove that. And that seemed particularly difficult within the context of software or a deep learning method.
And it's not only very difficult, but even with standard software-based, the traditional enterprise technology, when you're incorporating a language or output language and trying to compare it to a different set of patent infringement, I've worked with experts over the years to try to prove that up and defend it defensively, and it's quite complicated, and the experts struggle with it, the judges struggle with it. At the end of the day, it tends to come down to what the words in the claim mean and what the experts are describing in terms of how the code interacts with those terms, right? So it's really trying to teach a generalist judge that doesn't have a software background in most cases concepts in terms of software language found in patent claims and how they actually relate to how the code functions in practice. That is always, in every case, a huge challenge.
Interesting. Thank you very much.
Well, that was a great question too. But if Antigone can stick around if there are any other questions, and if we have the Zoom channel, do we have the Zoom channel? If those two meet, then we can close off the official BME-X. And thank you, Antigone, for this. Imagine applause from 25 people that are still around. So yes, we'll do it. Jeff and I will do our thing. But if you can stick around for a few minutes, and Jeff, can we have the channel, or do you need it?
Oh, Chuck, I'm just going to say again, a special thanks to Antigone. That was what a great talk. It was just so clear, so lucid, and I really enjoyed everything that you shared with us. Thanks very much for that. And Chuck, again, I want to thank you for organizing.
Oh, nope.
Yeah, I can to your question, I'll leave it to you to conclude, Chuck, but I will leave this channel open, but we'll adjourn, and I'm going to make you the host, Chuck. So it's
What power?
Yes, indeed.
Okay. Well,
Thank
not
you
only
both
that.
again, and thanks everyone for attending.
Thanks, Jeff. Not only that, we'll open it up here. If anyone has a question, just unmute and ask the question. If we get a conflict, we'll resolve that. But if there are any other questions, time not to be shy, but it was that clear.